Naam, karibu sana mtazamaji, tuelekee moja kwa moja sasa hadi kaunti ya Nakuru ambapo mwenzangu Ruth Sarmwe anafuatilia taarifa kuhusiana na washukiwa wa uhalifu katika kaunti ya Nakuru. Kumbuka kwamba kumekuwa na mauaji ambayo yametekelezwa katika eneo la Mawanga, watu 6 wameuawa na kuna washukiwa ambao wamekamatwa sasa hivi wako mahakamani. Ningependa sasa tuelekee moja kwa moja hadi mahakamani kule na tusikize kuna yapi ambayo yanajiri sehemu hiyo.
As opposed to a complainant. It's only Article 51 that talks about the rights of the complainant. The rest of the provisions therein speak of the right of an accused person who is given a bigger chunk of this right by virtue of him being the person to be affected by the decision to be arrived at. Now, one of those rights, my Lord, is a right under 52B to be informed of the charge with sufficient detail to answer to it. So that when the petitioner moved to the IBC DRC committee, they ought to have informed our client, the fourth respondent, sufficiently with details of the allegation against him for him to be able to answer to that allegation. Now, the complaint we received was based on speculations, on conjectures, on guessworks, on an invitation to the tribunal to draw inferences and conclusions. And that is the complaint we answered to by way of a response. We filed an affidavit rebutting that, and we filed our submissions on 13th of June. Then on the day of the hearing on 15th, now the petitioner brings a document that sought to restructure the substratum of their complaint based on evidence that was not availed contrary to Article 52B of the Constitution. Article 52J, my Lord, before I move to that, let me talk about Article 52C. That the right to fair hearing also entails adequate time and facilities to prepare for a defense. So it is not enough for the petitioner to argue that that information was within our knowledge. That article provides that we must have been given adequate time and facilities to prepare for our defense. So that it was not fair for the petitioner to come before court on the morning of the hearing, having put in our submissions, introduce a new document with zero chances of us preparing for a defense. That would have contravened Article 52C of the Constitution. Lastly, my Lord, the right to fair hearing entails the right under Article 52J to be informed in advance of the evidence the prosecution intends to rely on and to have reasonable access to that evidence. My Lord, it is on the basis of those glaring attempts to violate the fourth respondent's fair hearing that we made an objection to the introduction of these other documents. And the tribunal agreed with us 100%. How then, my Lord, can we fault the second respondent for protecting the rights of both parties? By the time the complainant was moving to the tribunal, he ought to have prepared their case, presented it well, and supplied the accused person, who is the fourth respondent, in a manner for them to be able to adequately answer and defend those allegations. We submit, my Lord, that appearing before you today and accusing the first, second, and third respondents of violating their rights is an afterthought. The reason why I'm saying that, my Lord, is that you will go through the proceedings. You'll find that the decision to expunge that affidavit.
Naam, basi mtazamaji, hiyo ni kesi ya washukiwa ambao wamekamatwa katika kaunti ya Nakuru. Nadhani kwamba wanapata washukiwa 6 hivi kama sijakosea, ambao wamefikishwa tayari mahakamani kujibu mashtaka ya uhalifu katika kaunti hiyo. Kumbuka kwamba kuna kundi ambalo linafahamika kama Confirm katika kaunti ya Nakuru na limehusishwa na mauaji ya watu, tukizungumzia watu zaidi ya 6 hivi ambao wameuawa katika kaunti hiyo ya Nakuru katika hali tata. Na hivyo basi ni kesi ambayo inaendelea kwa sasa. Mwanahabari mwenza Ruth Sarmoi kutoka kaunti ya Nakuru atakuwa anatufahamisha kwa kina zaidi kuhusiana na kesi yenyewe imefikia wapi hapo baadaye, hasa mwendo wa saa 7 hivi kwenye NTV Adhuhuri.